As you know, I was out of town when the U.S. Supreme Court issued their order list. So I had to do a super quick video about the order list that denied cert in the Illinois quote-unquote assault weapon cases and GVR, the 922G cases, back to the lower courts, and did the same with the Antonyuk case out of New York. So I now want to sort of break down what I think happened with the U.S. Supreme Court. And no, I don't think this is bad news, although I would have liked to seen the Supreme Court take one of the semi-automatic rifle ban cases out of Illinois. The reality is I'm not shocked that they refused to do so because of the interlocutory nature of that matter. With that said, we're going to break down these cases, what I think the Supreme Court was thinking, and where we go from here. I don't think it's terrible news, although, of course, if I had my druthers, we'd be in a different position than we are right now. But again, in the grand scheme of things, I think we're doing fine. Let's break it all down when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed: What the 10/7 Attacks on Israel Teaches Americans About the Right to Bear Arms. I appreciate those of you who've bought the book, and for those of you who've bought the book, if you're so inclined, feel free to do a review on Amazon. That always helps to show people that the book is moving, and it's also helpful for me to get feedback as to if you like the book or dislike the book. It helps me going forward with other projects. So anyway, check out on Amazon.com, Israel Disarmed, my latest book on Second Amendment related issues. All right, folks, so we got to get geeky on this. I'm just going to tell you now. And again, as a reminder, it's not my job to tell you what I want to do or what I would do if I were on the Supreme Court, because that doesn't do you any good, because I want to speak to you about where I think we are in the real world, giving you real world information and not fantasy land stuff that I might like to have happen, but we simply can't get to certain places in my view, and I want to break it down. So with that said, I want to talk about this Supreme Court order list, where they made a series of decisions, most of it was kind of expected. One is they GVR'd, which meant that they granted cert, vacated the lower court orders, and sent them back for further consideration in light of Rahimi, all of the 922G cases. Those 922G cases, the 922G1 cases, as a reminder, the 922G cases all dealt with quote-unquote prohibited people that were not allowed to possess firearms, either because they were using illegal drugs, they were convicted felons, as that's defined by federal law. They had some other issue associated with them that prevented them from having or possessing firearms for one reason or another. Now, the Supreme Court dealt with the 922G case in Rahimi, and what they basically did is, having decided that in Rahimi, they exercised really like standard operating procedure, and they GVR'd all the cases that could conceivably have been impacted by anything in the Rahimi case, and that's why those cases dealing with 922G issues were sent back down for further consideration for the lower courts to take another crack at deciding those, in light of the fact that Rahimi is a Supreme Court decision that addresses 922G related issues and standards. And as a reminder, Supreme Court cases have two critical parts. One is, of course, you care about who wins the case, but from our perspective in the Second Amendment community, in many instances, it's far more important as to how they win or how they lose the case, because it's the methodology, it's the thinking, the interpretation of the Second Amendment right that is going to guide lower courts and the Supreme Court going forward. So with that said, the 922G cases, prohibited people cases, were largely going to be governed in one way or another by the Rahimi decision, and that's why they were all sent down. Now, the one case that I think is eventually going to get to the Supreme Court, as we've talked about before, is the Range case, Brian Range versus Merrick Garland, out of the United States Court of Appeals for the Third Circuit. That's the Delaware, Pennsylvania, New Jersey court. And in that case, they found that Brian Range was not violent or dangerous in any respect and was entitled to have his rights, his Second Amendment rights restored. And that 18 U.S.C. 922G1 that says that felons are not allowed to possess firearms, that didn't apply to him, because they said that dangerousness is the measurement as to when someone can be disarmed, not a label by the legislature that someone committed a felony as defined by the legislature. And that's why I think the Rahimi case is very good news for us, and it's what I predicted and I told you about, which is The key we wanted in Rahimi was to say that if there's a finding that you are a violent danger to somebody else, you can be disarmed during that time that you're a violent danger to somebody else. And that means people like Brian Range and other people who were never violent. They were always nonviolent, but yet they committed either they lied to the FBI like Martha Stewart, or they committed a white-collar crime, or they did some sort of bookkeeping issue, or they engaged in some other nonviolent activity, but that was technically considered a felony under state law or federal law. They would be disarmed for life. And it's pretty clear in my reading of Rahimi that the Supreme Court is not going to allow people to be disarmed for life because of something they did at the age of 18, unless conceivably what they did at 18 was super duper violent and bad. Now, I want to remind you before we move on to the Illinois assault weapon cases and also to the Antonyuk case the following. Let me be very clear about this. Even though I care about 18 U.S.C. 922G cases, I really do, and I want to win those cases. I want to be very clear about one thing, strategically. This is a strategic discussion we're going to have here, folks. 922G cases and Second Amendment challenges involving 922G, federal gun control law, 922G, prohibited people. These are not good cases right now for us to be litigating as a general matter. The reason why I say this, if you think about it, but people that get implicated by 18 U.S.C. 922 are people that have either been convicted of a crime, so they're criminals at some point, okay? They were criminals. This court doesn't generally like criminals as a general matter. They're not sympathetic to criminals. So having somebody who's a convicted criminal be vindicating our Second Amendment rights is not the best posture strategically for us to be in. It's just not the best look. The optics are not great to have criminals representing us and trying to vindicate their Second Amendment rights. Even though I may cheer for them in their cases, the reality is it's just not the best view. It's much better cases to have someone who's never been convicted of a crime vindicating our Second Amendment rights than criminals. Likewise, under 922G, we also see, illegal aliens. We see people that have been, committed involuntarily to a mental health institute. We also see people who are users of illegal drugs. Again, this court is not particularly sympathetic to people that use illegal substances. They don't like drug traffickers. They generally don't like drug-related anything. So again, it's not great to have cases like the Daniels case involving a person convicted of using illegal drugs at the same time possessing firearms. It's just not a good optic look for us. It's not a good strategic look. So the fact that the 922G cases were not granted cert now and were instead, they were granted cert and then vacated and sent back for further consideration. I'm not unhappy that the Supreme Court has not taken any of these 922 cases on its own right now because, again, Merrick Garland wants to talk all about criminals in front of the Supreme Court because he knows that gives him the best possible chance to cut away and eat away at the Bruin-Heller standards, whereas we're much better off having, people with perfectly clean records that have never harmed a fly, they've never been in trouble with the law or anything like that. It's much better to have them trying to vindicate Second Amendment rights than anyone with any kind of a problem on their record. It's just strategically the way it works. So I'm not offended by the fact that 922G cases were sent back. I also wonder whether or not the Supreme Court itself was thinking along these lines when they said, look, we just took a 922G case involving Zaki Rahimi. He was a total scumbag on this record. We don't need another 922G case to deal with right now. Let's just kick that down the road. We'll deal with another Second Amendment case that doesn't involve, alleged scumbags in the near future. That's what I think they maybe have been thinking and why they did this, even though they, things like range are not violent at all based on the record. So that's it. Now, the Illinois assault weapon cases, I thought this was going to be a problem. I thought the best chance we had for a semi-automatic rifle ban case to get before the U.S. Supreme Court was the Bianchi case out of the United States Court of Appeals for the Fourth Circuit, which had been argued, and there was games by the Fourth Circuit. But when the Supreme Court denied cert to the Bianchi case a month ago or so, I thought it was going to be extra hard for the Illinois cases to be granted cert. Again, the way to think about this is this. Right now, as we sit here, there is no circuit split involving semi-automatic rifle bans. There's no court that has come out to say that a ban on semi-automatic rifles is unconstitutional. The only example we see of this is a dissent by, for example, Justice Kavanaugh, who was then a judge on the D.C. Court of Appeals. But again, there's no circuit split here. That's one thing to keep in mind. Beyond that, the most important reason why I think they denied cert in the Illinois cases is because they're interlocutory in nature. The procedural posture was the cases had not been completed yet. And as a reminder, what interlocutory means is a case is before final judgment. Those were litigations that were brought up to the United States Court of Appeals for the Seventh Circuit in front of anti-gun Judge Frank Easterbrook and anti-gun Judge Diane Wood. And in a 2-1 decision, they said that the law of Illinois that banned semi-automatic rifles in various ways and magazines that hold more than 10 rounds and so on, that these were constitutional. But they specifically said in their opinion, because Judge Easterbrook, while he's terrible anti-gun and in my view a terrible judge and a total disappointment as a Reagan appointee, but that's a conversation for another day, he specifically wrote in his opinion, because he's a smart guy, that he's not ruling in favor of the Second Amendment, depending on what happens in the lower courts in terms of the factual development. So he basically indicated, hey, my mind is not made up yet. I'm still willing to consider things, but on this record, on a preliminary injunction basis, I'm not going to allow for the law to not go into effect. So basically, I think the Supreme Court looked at this interlocutory appeal and they denied cert on that basis. Now, I'll tell you what, I thought this was going to happen because if you looked at the Idaho abortion case earlier this term, about 3 or 4 weeks ago, the Moyle case, M-O-Y-L-E, the Moyle case involved this sort of alleged debate really between whether or not federal Medicare, Medicaid abortion-related laws could somehow override a anti-abortion state law by Idaho, and which took precedence over the other. I'm not going to bore you with the details of that case beyond to say that if you read the decision in Moyle and the concurrence and dissents and whatnot, I forgot what it was by Justice Alito, he basically says, why are we taking these cases on an interlocutory basis? We should just let the lower courts resolve these on a final judgment, and then we would take the case then, because Moyle was taken on an interlocutory basis, and basically the judges dismissed that appeal as being improvidently granted, saying, yeah, we've looked at this and we realize we shouldn't have taken this case. And again, Justice Alito said, why are we taking these cases on an interlocutory basis? In the first place, we should just let it play out in the lower courts in the normal way. So again, when I saw that Moyle decision came out, it told me the Supreme Court's very focused on interlocutory appeals, and because the Illinois case was on interlocutory appeal, that was a sign that they weren't going to grant cert in that, because again, they really want a final judgment, in part because they want to know all the facts, they want to see all the arguments, they want to get all the development, and then they can make the best possible decision on the merits, and they don't like surprises or things or curveballs or anything like that, because they know that whatever they say is going to be binding on the whole country for decades to come, potentially, and they don't like making big-time decisions, which every Supreme Court decision is really a big-time decision, and they don't like doing it until they have a complete record with all the available information in front of them, so they make the best possible decision in that particular case with all the information available, and they don't like doing it on partial records, because the last thing they want to do is to issue a decision and then new information comes to light down the road, and that somehow might have altered their decision in the first instance. So that's why they like to make these decisions as a general matter on final judgments. I will digress just briefly to say, some people said, well, what about the Donald Trump case? The Donald Trump case was taken on an interlocutory basis because, A, it was unprecedented to have a president indicted, so that alone justified the Supreme Court getting involved. But there's a more pedestrian reason why they took the case, is if you're dealing with an immunity defense, you have an appeal as of right. That doesn't mean the Supreme Court has to take your case, but as a general matter, if you have an immunity defense, the appellate courts will usually weigh in pronto, because the notion of having immunity is not only are you not going to be found guilty of something, but it also allows you to avoid going through the headache of a lawsuit or a criminal case in the first instance, because you have immunity. So that's the other reason why they took the Trump case on an interlocutory basis, but they didn't take the Illinois assault weapon case, which again did not speak to immunity issues, but the Trump case did. And that's why somebody says, well, they took the Trump case, why not the Illinois assault weapon cases? And that is one of the reasons why. unprecedented because it's the President Trump election year, and of course the immunity defense triggered an automatic right to an appeal. And the last case is the Antonyuk case out of the Second Circuit, United States Court of Appeals for the Second Circuit in New York City. The two issues presented, 1791 versus 1868. We'll do another video on that. But the U.S. Supreme Court in Rahimi specifically said they're not going to touch on that issue right now. There's some strategic reasons why I think they don't want to ultimately decide, but there's no doubt in my view when they do decide it, the answer will be 1791. That is pretty clear as to where this court will come down when they have to decide that issue. The second issue presented in the Antonyuk case was the issue associated with good moral standing under the licensing rules and whatnot. And as you may recall, the Rahimi case actually spoke to that because the Rahimi case undeniably rejected the Department of Justice's argument that they could disarm people who were not responsible, meaning if you're irresponsible, that alone was a basis for being disarmed. The Supreme Court 9-0, because it was 8-1 plus Clarence Thomas agreed, said that just because you're not responsible, just because you're irresponsible is not a basis for being disarmed and losing your Second Amendment rights. That is a no-go zone. And that's why I think the Antonyuk case was sent back to the U.S. Court of Appeals for the Second Circuit, because one of the big arguments in the Second Circuit was, well, you got to make sure that people are responsible to have guns. And the Supreme Court said that is simply not the standard. Either you're violently dangerous, at which point we can disarm you. If you're established to be violently dangerous after a court hearing, we can disarm you temporarily. And if you're not violently dangerous, there's no basis for disarming you. And certainly you cannot argue that someone is irresponsible, and that's a basis for disarming you on the Second Amendment. That is clearly 9-0, a no-go according to the Supreme Court. So that's why the Antonyuk case was sent back for further consideration in light of the Rahimi case. All right, so where are we going to go from here? It is still very early on in the year of our Lord 2024. And my prediction will be there will be one, if not more, Second Amendment-related cases in the 2024-2025 term, which runs from the first Monday of October 2024 to June of 2025. Okay. The cases, if you force me to guess which cases are going to go to the U.S. Supreme Court next term, it's a little bit of speculation here, but I think that the Reese case, which I've talked about on this channel before, out of the United States Court of Appeals for the Fifth Circuit, will go to the Supreme Court. The Reese case deals with 18, 19, and 20-year-olds and their ability to acquire firearms from FFLs. Again, it's an 18, 19, 20-year-old case, whether or not 18, 19, and 20-year-old Americans have the same Second Amendment rights as anybody else who's over the age of 20. That Reese case, I believe we will win that case in the U.S. Court of Appeals any time now. When that decision comes out that declares part of a federal gun control law to be unconstitutional, that will force the U.S. Attorney, it was going to force the Merrick Garland and the Department of Justice to seek an appeal to the U.S. Supreme Court and seek cert through the SG's office, the Solicitor General's office, and almost certainly the U.S. Supreme Court will grant cert in that question of 18, 19, and 20-year-olds, and I believe we have about a 95% plus chance that we will win that case, that 18, 19, and 20-year-olds have full-blown Second Amendment rights, just like everyone else does. And that, I think, will be next term, the Reese case. Beyond that, keep in mind the Bianchi, the U.S. Court of Appeals for the Fourth Circuit. In the Bianchi case, we're still waiting. There was oral argument in that case already. At some point, they're going to issue a decision. We'll see what happens. Maybe they're waiting to see who wins the election. There's also the Laura case out of Pennsylvania. I think it's kind of a quirky case procedurally. The Laura case, you may remember, that's another 18, 19, 20-year-old case. But I think that arose out of a kind of weird situation about who's allowed to carry guns or have guns in the context of a declared emergency or like a pandemic. So the Laura case is another 18, 19, 20-year-old case. And again, I think there's other cases percolating up. Remember, there's two buckets of cases that are always percolating involved in the Second Amendment. You have civil rights cases and lawsuits brought by people that are trying to vindicate Second Amendment rights. A lot of these may be nonprofit Second Amendment-related organizations are bringing lawsuits with favorable fact patterns and favorable plaintiffs with good records. But then you have the other bucket we saw in Rahimi, which is people with criminal records or in criminal cases represented by public defenders in many instances. Hunter Biden would be another example. Not that he's represented by a public defender, but that would be another example. So you have these criminal cases that are also making their way through the system, and one never knows when you're going to get a civil case, which was Heller, which was McDonald, which was Bruin, or you're going to get a criminal case, which was Caetano, for example, and Rahimi. So again, we don't know where all those criminal cases are. There's thousands of them across the country, and you never know when one's going to pop up and percolate all the way up to the U.S. Supreme Court like Rahimi did. So anyway, with that said, I hope this helps you understand. I think the Supreme Court's thinking on this. I do think we'll get Second Amendment cases to be decided next term. I don't think we're going to find out what they are until September, October, but for now, there are no Second Amendment-related cases unless you want to consider the Vanderstock case a Second Amendment-related case. Just to jog your memory, Vanderstock is a lawsuit challenging the ATF's authority to redefine what a frame or receiver is to include partially made frames and partially made receivers, as well as weapon parts kits that do not include frames or receivers. So I think that the ATF is probably going to suffer another big loss in that case in the same way they did in the Cargill case dealing with bump stocks, but we will not know that. I think oral argument will likely be, I'm guessing, October, November 2024. But again, I'll keep you apprised of the Vanderstock case, which is a gun-related case involving the ATF's powers, although not specifically a Second Amendment case. All right, folks, so hope you did not get too geeked out on this, and make sure you follow me on X at @4boxdiner and subscribe right here to this channel. I'd appreciate this as we continue to grow the channel. Don't forget to check out Amazon, Israel Disarm, and we'll see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.